afternoon. So we are going to discuss about compulsory licensing. Compulsory licensing has been a major phenomena which is being utilized by companies to ensure that a product is available in a market at an educated number. So where do you use a compulsory license? When a patent holder acquires a patent, he acquires certain amount of monopoly over that patented product. In order to exercise his monopoly rights, he has a right to circulate that product in a particular market. But sometimes condition may arise that another company or a market requires a product which is very essential to it, but the company that is manufacturing or the patent holder is not able to provide that product in a sufficient number. In that case, the resort which the countries have is comes in a form of compulsory license. Compulsory licensing was first introduced in Paris Convention and was later taken to the TRIPS Agreement. Compulsory licensing is a way of flexibility is granted to developing and developed countries so that they can protect their interest. See, most of the time, compulsory licenses are being utilized in pharmaceutical sectors, where, for example, if a company like Abbott is producing a drug which is essential and is very costly, and it's coming in a developing country for a very high price. Then in that case, it is a flexibility to a developing country to grant a compulsory license to any of its local partner and manufacture the same product. What we have to really keep in mind while we're discussing compulsory license that it is still a license. And therefore, at any rate, whenever a compulsory license is issued, there will be a system of royalty. That means the patent holder would be paid something against a compulsory license which is issued in his favor. Now, Article 31 of the TRIPS Agreement deals with compulsory license. Now, just understand one simple thing that TRIPS Agreement is an agreement that deals globally on the issue of IPRs. What TRIPS actually does is to provide minimum requirements which every country has to fulfill while they are drafting their own national IPR laws. Under the provision of TRIPS, Article 31 is one of the sections which deals with compulsory licensing granted under the domain of patents. So first, what is a compulsory license under a patent? Compulsory license simply means that a license would be issued to a third party to manufacture the same product or use the same process as that of a patent holder by giving him a certain amount of royalty. Now, Article 31 is a core provision. It does not give any detail of how to implement the provision. Rather, it gives you a detailed guidelines, simple guidelines, which needs to be there while any country drafts its compulsory licensing process. When you talk about India, Section 84, Section 92 and Section 92A of the Indian Patent Act 1970 deals with compulsory licensing and in reality are in line with the provisions of Article 31. Now, Article 31 would give you just some guidelines. First, whenever you issue a compulsory licensing, authorization needs to be granted. Without authorization from the patent holder, compulsory licenses are not issued. Second, compulsory licenses are not a general practice, rather they are something which is done in exceptional circumstances. For example, in cases of national emergency, extreme urgency, or some non-commercial use. A commercial use at a large scale is generally not permitted. The scope and duration of such compulsory license should always be mentioned while it is being issued. It is always non-exclusive and non-assignable. That means once a compulsory license is issued, it cannot be assigned further or transferred further to any other person. Such licenses are predominantly issued for the purpose of domestic markets and not for export purposes. Thus, whenever such licenses are issued, they have to be issued with adequate protection of the legitimate interest of the person so authorized. The right holder will always be paid with adequate remuneration for the issue of compulsory license, and he will further have a right to appeal and sub-appeal to any judicial or administrative agency, whichever is responsible for taking into the matter of compulsory license. However, one exception is again provided for countries like developing and least developing countries, that they can pass all these obligations if they're able to prove that the company, which was originally a patent holder, was actually attempting to make an anti-competitive practice. Now, some additional points are also there, that if there is a compulsory licensing of one patent where there is a requirement of second patent also, then in that case both the patents would be compulsory licensed. Now, another point which I want to discuss is the Doha Declaration. See, Doha Declaration is just a reiteration of the obligation given under the TRIPS provision. First, you have to understand that Doha Declaration deals only with public health and not to any other matter. It was being formulated in 2001 when Ministerial Committee of TRIPS again met. Paragraph 4 of that Doha Declaration, which is important for compulsory licensing, especially states that all countries have an obligation to maintain their public health and they have a right to take all measures which are essential for maintaining that mental health, their public health of their community. For that purpose, they are again telling all the nations that we are reaffirming our obligations granted under TRIPS, but along with that, the flexibility granted under TRIPS should be utilized. See, the purpose behind this special commitment of Doha Declaration was, even after such 8 or 9 years of coming of force of TRIPS agreement, countries were reluctant to grant compulsory license. You have to understand that a country which is least developing or developing countries are already under pressure from developed countries for supply of medicines in their country. Now, in that situation, for them to issue a compulsory license is not an easy task. Doha Declaration always talks about this. Now, what Doha Declaration did was to widen the scope of compulsory licensing by issuing certain additional points that each country would be allowed to decide what would be the grounds for which they are going to grant compulsory licensing, and any kind of public health problem like HIV, AIDS, malaria. See, there are still African countries for whom malaria is a bigger problem than any other disease. And there are countries for whom malaria is not even a problem. But it depends upon your geographical location, your competence in medicine market. So this was a flexibility which was widened through Doha Declaration, whereby countries are allowed to uh, evaluate their own circumstances and note what could be a national emergency for them. Now, this is the Indian position. We'll discuss this position in a later video.